of all, we had a very sophisticated buyer and a very sophisticated seller. Right? It wasn't Bob and Mary or Jim and Ann buying their first home, being preyed on by us. One guy was a broker for Merrill Lynch, and the other guy was something with the bank. And so presumably they have some sophistication, at least to how to get government money. In any case, I say that. In any case, and they each had a lawyer. So that in talking to the listing broker, I wasn't concerned. If something goes wrong with that, that will be the last person who someone will be looking at, because we had lawyers on each side with two sophisticated parties. But I want you to understand, if you run into a situation where a buyer is willing to buy, and the amount of the mortgage is going to exceed the amount of the land contract, or the monthly payment is going to exceed, and the mortgage is going to exceed the land contract, do not close without them seeing a lawyer, so that they can't claim that the situation wasn't properly explained to them. Because all that's got to happen is for that seller to quit paying that mortgage. And what incentive do they have? I mean, in some respects, they may well take the position, well, I've got this people here, they just put $30,000 down on a land contract. Are they really going to, they're going to let this property go? Are they going to step up and pay my mortgage for me? So that's a very, very difficult situation. And again, if you're not putting this provision into the land contract, then you need to have a lawyer draft the provision that should be in there, that the buyer acknowledges and agrees that the balance of the mortgage exceeds the balance of the land contract, blah, blah, blah. So there's no question in anybody's mind that they knew what was going on, and this was the result. There's no provision in this land contract regarding what a buyer can or cannot do with the physical improvements to the property. Okay? If you're representing the seller, you're going to probably want a provision in here that prohibits the buyer from making anything other than cosmetic changes to the property without the seller's consent. I mean, it's going to be a problem if they start gutting the first floor, get it gutted, run out of money, and leave. All right, so now you're taking it back. So that's a provision that, representing a seller, you're going to want in there. As a buyer's representative, you may well resist that. Now, let me move on to the final paragraph, because we have other things we want to get to. Paragraph 16. First sentence of this paragraph says nobody can record this contract. That should not be disagreeable to anybody. There's no reason why the seller or the buyer wants to put the terms and conditions of their transaction on public record. However, it then goes on to indicate that at the request of the purchaser, the seller will execute a memorandum of land contract, which may be recorded with the Register of Deeds. You have a sample of a memorandum of land contract. There are those who would say, McClellan, you stepped over the line. That's not a neutral provision. That's a buyer provision. And it probably is, but I wanted it in there so people representing buyers wouldn't forget it. The reason this is important is, remember when I started this talk, I talked about how courts treat land contracts, give them the same dignity as mortgages and the like. And they do. And if, in fact, there's a memorandum of land contract, the buyer receives the same protections as if they had fee title to the property or as if they were a mortgage holder. And the way that works is this. Let's assume that we do this land contract today. I think this is the 16th of June. And we do a Boy. Wow. Oh, man. I have got to. Oh, well. I always say I'm going to have 2 and I end up having 4. But in any case, so this would be dated the 19th. And it gets recorded in the Oakland County Register of Deeds on the 19th, 2009. We're now in the second year of the land contract, and lo and behold, I, as the seller, have failed to pay some taxes. And a federal tax lien hits and a state tax lien hits. All right, and then we come to the third year. You're getting ready to pay the balloon. You, as an ounce of caution, since you already got your title policy up front, you certainly are going to have the title search done, though, which I certainly always did if we were closing, to see if anything's happened between the date, June 19th, through the date we're closing in 2012. And lo and behold, I discover that there are two tax liens out there. There's a federal tax lien and a state tax lien. On the seller. Okay? So what do I do if I'm the buyer? Well, I was in that situation, had clients in that situation, unfortunately, a number of times in the 80s. So what we would do would be to start a legal action, unfortunately, and say, okay, we've got a balloon left to pay of $75,000. There's the seller we owe it to, but then there's this federal tax lien for $42,000, the state tax lien for $25,000. Judge, all we want you to do is declare us to have legal title free and clear of these things because we recorded and we predate them, and then tell us who we should pay them to. And we would serve the state, we'd serve the feds, and of course we'd serve the seller. And I will tell you, I must have had 7 of those lawsuits. I never heard from anybody except the seller. I mean, the state and federal never even responded. So what did we do? We paid the freaking seller. We got our deed, we got it free and clear. The only reason we did is because we had record interest of title. Just like if we'd have taken a mortgage on June 19th. Anything after that mortgage is subordinate to our interest. Same thing with the land contract vendee, memorandum of land contract. Now, why would a seller care about whether this gets recorded or not? I'll tell you why they care. We go ahead and we close today, the 19th. Year and a half from now, you know, I've had it. I've gotten divorced. Nobody likes me in Michigan. I just take off. I'm gone. Okay? I mean, I've always wanted to go to Belize City in Belize in Central America, and that's where I'm at, and I don't care. Okay? Now, you turn around, the property's no longer there. You want to sell it. I'm gone. You can't find me. So you list it, and you go ahead and list it, and you find a buyer. They pull a title commitment. All of a sudden, the title company sees this memorandum of land contract. Who's this McClellan guy? Well, he left. We hear he's in Central America. Whatever. All right? He's deranged. And what the title company will tell you, well, something's got to be done about this. Go get a release from McClellan. Release, hell, we can't even find him. Or file an action in the circuit court to quiet title, or go to the district court and forfeit the land contract. Which means that at a minimum, it's going to be 4 months before you close. That's why sellers don't want these things recorded. Because if things go bad, typically you can't get a release from the buyer. Everybody follow that? It's in that walk-away situation. Now, I will tell you, if you're representing a seller and a buyer insists that they're entitled to a memorandum of land contract, they're not as a matter of law, but as a matter of reasonableness, they certainly are. All right, because they essentially have more to protect in the future than the seller does. Okay, let me move on to the whole topic of due-on-sell clauses. Because there are people who have come up to me and said, well, we understand we can't sell them on land contract if there are due-on-sell clauses. Okay, again, when the Supreme Court of the United States determined that due-on-sell clauses were enforceable, again, we sat down and we negotiated with the banks. Because all our members had been out there selling land contracts with 3-year balloons, and now the lenders could foreclose on every one of those land contracts. So we sat down and negotiated with them. And we came up with something called a window period loan. And you'll see it in the statute. We do have the excerpts of the statutes, the materials in front of you. It talks about a residential window period loan. Forget about that term. All those residential window period loans were gone 20 years ago. What we did was negotiate a deal where if a land contract was written during a certain period of time prior to 1980, a certain date in 1984, the bank couldn't foreclose on it without first offering them a new mortgage at a blended rate and going through a bunch of steps. I mean, you see a reference in Section 8, Section 1, a lender who knowingly enforces or attempts to enforce a due-on-sell clause in violation of the Act is subject to $5,000. That's because they were required to do certain things to allow people to save themselves from due-on-sell clause. All those are gone. So if you look at Section 2, the first part of the section, any person is licensed to do business while carrying on knowingly advises a person